Got it. Start. I am Hema Rai, Assistant Professor of IMT College of Law. Today I'll discuss about the concept of Hindu law. Introduction of Hindu law. What is Hindu law? For the Hindus, law is a branch of dharma. Dharma prevails throughout the Hindu philosophical thoughts and the Hindu social structure. Law, in this sense, is considered as a branch of dharma. According to Manu, dharma is what is followed by those who are learned in Vedas and what is approved by the conscience of the virtuous who are exempt from hearted and inordinate affection. Further, Manu says that the term dharma stands for duty. It signifies the sum total of religious, moral, social, and legal duties. From this aspect, it has been said that Hindu system is a system based on duties. Hindu law is a law which emanates from smritis expounded in Sanskrit, commentaries, and dignity digests. These Smriti texts do not make any clear-cut distinction between rules of law and rules of morality or religion. These rules of religion and morality were dealt with at one and same place with the rule of law. In the case of Sri Balsud, the Privy Council distinguished between mandatory means legal rules and directory means moral rules. On this basis, an entire body of Hindu law has been built up. Even during the Mohammedan rule in the country, the Smriti law was continued to be fully recognized. Hindu concept of law does not conform to the Augustinian views. According to analytical jurists, most of the rules of Hindu law would be termed as no more than mere positive morality. However, it is now very well accepted that rule of law to be called as such need not emanate from a determinator or particular authority, and it need not be imposed on others by such an authority. Rules of Hindu law were as much rules of law as the commands of Austin sovereign because they were obeyed by the people for whom they were made. Hindu law in modern times, Hindu law as administered by the courts of India is applied to Hindus. But in fact, it is not the original Hindu law, which is applicable to Hindus in India. It is an amended and modified law which has changed and altered a considerable portion. Original Hindu law does not apply to all the matters. It is subjected to alterations and modifications. Original Hindu law has been interfered with by the changing demands and needs of the society. For instance, the natural law Hindu marriage is materially altered by the passing of the Hindu Marriage Act 1955. Adoption amongst Hindu is governed by the Hindu Adoption and Maintenance Act 1956. For matter of succession, there is the Hindu Succession Act 1956. Minors are dealt with by the Hindu Minority and Guardianship Act 1956, etc. The provision of these legislative enactments are prevailing over the original Hindu law. Now we will discuss, before what is the Hindu law, we will discuss what is Hindu, who are Hindu, who are Hindus. In the earliest time, the term Hindu had a territorial significance. It only denoted nationality. In fact, the word Hindu is of foreign origin. This designated came into existence with the advent of Greek, who called the inhabitants of the Indus valleys at Indoe. And later on, this designation was extended to include all persons who live beyond the Indus Valley. The Supreme Court has observed that the word Hindu is derived from the word Sindhu, otherwise known as Indus River. The Persian pronounced this word Hindu and named their Aryan Bhartan Hindus. Dr. Radha Krishnan has also observed that the Hindu civilization is called since its original founders or earliest followers occupied the territory drained by the Sindhu river system, corresponding to the northwest provinces in Punjab. This is recorded in Rigved, the oldest of the Vedas. The people on the Indian side of the Sindhu were called Hindus by the Persian and later Western endeavors. That is the genesis of the word Hindu. So the term Hindu had originally a territorial and not a cradle significance. It implied residence in a well-defined geographical area. The term Hindu has lost its territorial significance. It is also not a designation of nationality. To whom Hindu law applies? Hindu law applies to all the persons who are Hindus, but there is still no precise definition of the term Hindu, either at any status or in any judicial pronouncement. However, the question as to who is Hindu can be understood in a different way. It can be taken as to whom the Hindu law applies. Hindu law applies to some categories of persons. First, any person who is Hindu, Jain, Sikh, or Buddhist. Second, any person who is born of Hindu parents. And number third, any person who is not a Muslim, Christian, Parsi, Jew, and who is not governed by any other law. On the basis of the description of persons as above, it can be said that following persons are Hindus. Hindu by religion. Following two types of person fall in this category. Followed of Hindu religion, any person who follow Hindu religion, either by practicing it or by professing it, is a Hindu. Converts and reconverts of Hinduism under the codified Hindu law, any person converted to Hinduism, Jainism, Buddhism, or Sikhism in a Hindu. converts and reconverts to Hinduism under the codified Hindu law. Any person converted to Hinduism, Jainism, Buddhism, or Sikhism in a Hindu. The Supreme Court in Perumal versus Punswami observed that a person may be Hindu by birth or by conversion. No formal ceremony of purification or expiation is necessary to effectual conversion, but at the same time, a mere theoretical allegiance to the Hindu faith by a person born in another faith does not convert him to a Hindu, nor is a bare declaration that he is Hindu sufficient to convert him to Hinduism. But a bona fide intention to be converted to the Hindu faith, accompanied by conduct unequivocally expressing that intention may be sufficient evidence of conversion. A person who is converted to Hinduism, Jainism, Buddhism, or Sikhism is also a Hindu. A person who ceases to be a Hindu by converting to a non-Hindu religion will again become Hindu if he reconverts to any of the four religions of Hindu. Hindu by birth, following person are deemed to be Hindu by birth when both the parents are Hindu. Children born of Hindu parents or Sikh or Hindus, such a child may be legitimate or illegitimate. It is also immaterial that such a child does or does not profess, practices, or has faith in the religion of its parents. When one parent is Hindu, when one of the parents of a child is Hindu, and he is brought up as a member of Hindu family, he is Hindu. It is clear by explanation of section 2 clause 1 of Hindu Marriage Act 1955 that child's religion is not necessarily that of the father. Or instance, a child is born of Hindu mother and Muslim father, the child is brought up as a Hindu. Subsequently, mother converts to Islam. Nonetheless, the child is Hindu. In Ram Prasad versus Dahin Bibi is a good example on this point. Persons who are not Muslim, Christian, Persian, the codified Hindu law lays down that a person who is not a Muslim, Christian, Parsi is governed by Hindu law unless it is proved that Hindu law is not applicable to such a person. Those persons who are atheists or who believe in all faiths or in conglomeration of faith may fall under this class. Under the codified Hindu law, such a person will be Hindu for the purpose of the application of Hindu law. Therefore, the modern Hindu law is a body of rules of personal law applicable to Hindus as well as several non-Hindus communities. In the modern Hindu law, all those persons to whom Hindu law applies are called Hindus. Now we will discuss in shortly sources of Hindu law. Hindu system of law has the most ancient pedigree of the known system of law. It is about 600 thousand years old and has passed through various phases. Originally, the sources came to serve the needs of pastoral people, and now it has come to serve the need of modern welfare society. It would be convenient to classify the various sources under the following two heads: ancient sources and modern sources. In ancient sources like Shruti, Smritis, and digest and commentaries, and custom, and modern sources. In modern sources like judicial decisions, legislation, equity, justice, and good conscience. After independence, following enactment of for reaching importance have been passed. The Hindu Married Women's Right to Separate Residence and Maintenance Act 1949. The act permitted a Hindu wife to reside separately and to get maintenance from the husband in certain cases. The Special Marriage Act 1954, it valid marriage between two persons who belong to two different religions. The Hindu Marriage Act 1955. The act has completely overhauled the relating to marriage between Hindus, including Jain, Sikh, Buddhist. The Hindu Minority and Guardianship Act 1956, it supplemental the existing law in the matter. The Hindu Succession Act 1956, it introduced some remarkable changes in the law of succession. It provides for the equal rights of inheritance of Hindu females and granted absolute right to whom with respect to a property acquired by them through any lawful means. The Hindu Adoption and Maintenance Act 1956, it was meant to bring about some changes in the act. Marriage Law Act 1976, it was meant to bring about some changes in the Act of 1955. It introduced divorce by mutual consent, common grounds for judicial separation, and divorce, and also relaxation in the rigorous process of obtaining divorce. The Child Marriage Restraint Amendment Act 1978, the act provides the eligibility as to the age of male and female at the time of marriage. Nature of Hindu marriage. Hindu marriage is a sacrament or contract. Institution of marriage has a paramount status in the social life of Hindus. It is one of the oldest institutions. The acceptance of Briz as his wife by the bridegroom in a gift by her parents is defined as a marriage. By marriage, man and woman are united into a wedlock. A Hindu marriage is looked upon as a something which is more of a religious necessity and less of physical luxury. The purpose of marriage is generally to give birth to a male child. It is believed among Hindus that every Hindu is under a religious obligation to discharge three debts: Pitrarin, Devrin, and Rishirin. Rishirin is discharged by getting education. Devrin, Devrin is discharged by prayer and by making gift. But for the discharge of Pitrarin, a Hindu must have his own son who is supposed to perform funeral rites and to give scared obligation to the ancestor of their death or their salvation. Marriage is also necessary among Hindus because all the religious ceremonies and rites are to be performed in the companionship of his wife, otherwise, they will not bear any fruits. From the Rig Vedic period, marriage, of, marriage was considered as a sacramental union. A marriage is the union of flesh with flesh and bone with bone. It is a union which is indissoluble as long as her husband is alive. The wife is enjoined to regard him as her God. Likewise, the wife is declared to be half the body of her husband, who shares with him equally the fruits of all acts, good or bad. Man is only half, not complete, until he marries. The wife is the source of dharma, earth, and karma, and she is also the source of moksha. The Hindu Marriage Act 1955 retains the provision relating to performance of ceremonies for a lawful marriage. It gives statutory recognition to the marriage under the Hindu law as a sacrament. Section 7 of the Act provides for the ceremonies of Hindu Marriage Act. A Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either party thereto. Where such a rites and ceremonies include the Saptapadi, like taking of 7 steps by the bride, groom, and the bride jointly before the sacrament fire. The marriage becomes complete and binding when the 7th step is taken. The section speaks of solemnization of marriage in accordance with customary rites and ceremonies. The word solemnized means to celebrate the marriage with proper ceremonies, with the intention that the party should be considered to be married. In one case, it was held that merely going through certain ceremonies with the intention that the parties be taken to be married would not make the ceremonies prescribed by law or approved by any established custom. So under the section, it is sufficient if the marriage is solemnized in accordance with customary rites and ceremonies of either parties. It is not necessary that the customary rites and ceremonies of both the parties should be followed. In Asrabai versus Donediram, where a marriage is performed according to the customary rites and ceremonies of one party, which did not include Saptapadi, even though according to the customary rites and ceremonies of the other party, Saptapadi was an essential ceremony. It was held in, it was a valid marriage. Now we will discuss Hindu Succession Act and Inheritance Act 1956. This act may be called the Hindu Succession Act 1956. It extends to the whole of India except the state of Jammu and Kashmir. This act applied to any person who is a Hindu by religion and any of its forms of development, including Brahma and a person, Arya Samaj, Brahma Samaj, and to any person who is Buddhist, Jain, Sikh by religion, and to any other person who is not a Muslim, Christian, Parsi by religion, unless it is proved that any such a person who not have been governed by the Hindu law or by any customs. Thank you.